Good afternoon and welcome to the Technology and Access to Justice lecture series at UNB and UNB Law. Thank you very much for joining us today in what is the first lecture for the term and for the calendar year. We initiated the series last year and have been exploring various topics at the intersection of law, technology, and access to justice. The lectures are hosted virtually by the Legal Innovation Laboratory at the Faculty of Law on the University of New Brunswick, and we recognize and respectfully acknowledge that the UNB law community gathers on the unsurrendered and unceded traditional lands of Wolastoqey. With the lecture series, we wish to promote knowledge exchange between New Brunswickers and experts from other parts of Canada and the world who work in the technology and access to justice space. I also want to give the official notice that we're recording the session for our archiving purposes. It is my great pleasure to introduce our speaker, Professor Katie Szilagyi, from the Faculty of Law of the University of Manitoba. Welcome, Katie. And Dr. Szilagyi will discuss her recent paper, which is entitled Regenerating Justice, ChatGPT and the Legal Minefield of Generative AI. The very timely and insightful piece was published with the Canadian Journal of Law and Technology in 2025. I will post a link to the SSRN version of the article, which I have also circulated with the invitation. Katie's research focuses on law and technology. In her work, she has called for greater scrutiny of the potential impacts of artificial intelligence and machine learning in law. This is an argument which I think is reflected in the paper that we will discuss today, which emphasizes that these technologies, AI and machine learning, have the potential to erode fundamental ideals, including the rule of law. The paper focuses specifically on generative AI technologies, their characteristics, their limitations, and puts forward a very carefully developed argument that the widespread use of generative AI risks muddying the waters of human expertise, including in law, and will likely have serious consequences in the legal space. More specifically, the paper claims that the use of generative AI to produce legal knowledge risks the creation and propagation of sourceless information, undermining law's key social systematizing function, and I'm quoting from the paper. And it adopts an automation bias lens. And I will defer to Katie to expand on the notions of automation bias as well as automation complacency, which I think are a very critical piece of this puzzle. And the paper really describes a low and incremental effect. It looks at the mental states associated with automation bias and complacency to foster over-trust and leading humans to delegate increasingly more and more tasks and responsibility to automated systems. And this dynamic, as we have all seen or we're seeing in our works, is becoming more and more evident in the legal domain. So I will pause here, reiterate my warm welcome to Katie and to all. Thanks so much for being here to discuss your paper. I look forward to hearing more about your arguments, the lens that you took, and I leave it to you to accept questions during the talk or after. And we'll open the floor for questions immediately after. The floor is yours.
Fabulous. Thank you so much, and thank you for having me. I'm very excited to be here with you today. I'm just getting over a cold, so I apologize if my voice is a little bit raspy, but perhaps that will just add to the background of the argument. So I want to start with a story, and this is a short story that my aunt had embroidered on a pillow on her wall in her office when I was growing up, and I would always look at it and think about it. This is a story about 4 people named Everybody, Somebody, Anybody, and Nobody. There was an important job to be done, and everybody was sure that somebody would do it. Anybody could have done it, but nobody did it. Somebody got angry about that because it was everybody's job. Everybody thought anybody could do it, but nobody realized that everybody wouldn't do it. It ended up that everybody blamed somebody when nobody did what anybody could have. So I'll invite you to keep that story in the back of your mind as we go through today's arguments about generative AI. And what I argue are some of the consequences for law's social functions, particularly its semblance of collective fictions and its ability to systematize information in a meaningful way. So let's start by talking about AI, because everybody wants to talk about AI, or at least they do now. I always joke that when I started my PhD in 2017, and I said I was going to do a PhD about AI and the law, people just rolled their eyes. They said, "Oh, what are you going to do with that? How are you ever going to get a job?" And I said, "Just wait," right? And what a world, what a sea change in the last couple of years in terms of public perception around AI and what it is and how it might impact our world, particularly our legal world. We have a lot of interesting questions that have arisen, but I think these have really crystallized in people's minds since the advent of generative AI. And what I mean by that is when ChatGPT broke onto the market in November of 2022. Right up until then, generative AI is kind of a lesser known technology. It's being developed in the computer science literature. OpenAI is certainly working on its earlier models. But apart from some academics, some computer science observers, some tech insiders, people aren't talking about it broadly. When ChatGPT bursts onto the scene in November of 2022, it gives many people their aha moment for what AI might be and how it might impact our lives. And it also transforms our understanding of what constitutes artificial intelligence, right? When are we looking at a computer program and saying that it exhibits some kind of artificial intelligence? When are we able to look at a system that is based in statistics or actuarial sciences and say, hey, actually, that is exhibiting something that is intelligence-like, right? I always joke that AI is just statistics with better marketing. And we really see in the last couple of years a transformation of tools that people have been using for a long time as being AI powered, and the advent of brand new tools that have been brought in order to mimic some of the skills that humans have long had. And this is important, this definitional exercise, because with the advent of ChatGPT, courts around the country sprung into action and said, hey, if lawyers are going to be using these things, we want to know about it. And so different courts took different positions. There were sort of two main positions that were expressed. One of them, which was typified by the example that the Court of King's Bench Manitoba gave, was that anytime lawyers are using artificial intelligence, that should be disclosed. The other approach was that, it could be used as long as there was a human in the loop, but it needed to be used responsibly and it needed to be understood by the people who were harnessing that technology. In all of these cases, it points to the lawyer's duty of competence that is required by the rules, and more specifically, an emerging duty of technological competence. An idea that lawyers, when they're using tools to be able to impact their practice, to deal with clients, to assemble information, to summarize things, should have an awareness of what those tools are and how they work. And this is important because the large language models that have burst onto the scene, specified most specifically by ChatGPT, do have some opacity in terms of how they work. And so one of the things that I do in this paper and in my upcoming book is I try to go into a lot of detail about how ChatGPT works. Because I think that people are excited about the technology and some of the efficiencies that it offers. And so they're happy to offload some of their mental load to it. Or perhaps on the other side, they're very scared of the technology. They don't understand how it works and they don't want to use it at all. And so both of these extremes are difficult positions to hold with respect to technology. And so how do we make sure that people who are using it well, and people are using it for the right applications? So here on the screen, we see a screen cap of ChatGPT's main page. And down at the bottom, you can see it says, ChatGPT can make mistakes. Consider checking important information. Read our terms and privacy policy. Right? So whenever I give this talk in person, I ask, all right, who's really read those terms and privacy policy? And we look around the room and no hands go up, right? So we become a little bit worried in terms of really understanding what the functionality of this type of tech is and how we should understand its contributions to the legal realm. So what is ChatGPT, right? ChatGPT is based on a technology that is a GPT, a generative pre-trained transformer. And what that means is that the technology is generating new information, right? It is generating something in response to the prompts that you give it. And the reason why it's able to do that so easily is because it has received a pre-training in how the language works, right? This allows ChatGPT to excel at something that's called zero-shot learning. It doesn't need to be given a bunch of examples in order to be responsive to your questions. It's able to do that right out of the gate because of the pre-training that it has received in how the language works. And the word transformer refers to the mathematical machinations going on in the background, right? Is a transformation vector that is used to take that text that you've inputted, change it into tokens, because we need to remember, ChatGPT doesn't deal with words as words, it deals with words as tokens, right? Which are mere chopped up versions of the word. Sometimes it's the whole word, sometimes it's less than the word. And then doing some math with that in order to come up with a probabilistic likelihood of what words should come next in response to the prompt that it was given. Now we can think about this through the lens of a really formal structural linguistics. Because a structural linguist would say, all right, there are two forms of language, long and pedal. And in long, we have grammar, right? We have the rules that are used to generate sentences. Those rules are finite and they are collectively held. So even though it seems like English has an exception to every rule, there's theoretically a finite number of rules, and everybody who uses the language is going to use those rules in the same way to communicate with one another. And that means that everyone collectively is harnessing those rules to generate their expression. But parole, or discourse, refers to the instances of observed sentences, right? How are people using language in order to say things? And that is an infinite possibilities. Anyone who speaks the language can choose to express themselves in the way that they see fit, right? It's a very individual process of conveying meaning, of engaging in a process of self-expression, of being able to use language in order to say things that are on your mind. And so when we think about an NLP, a natural language processor, which is what LLMs fundamentally are, right? Natural language processors are trying to reproduce those grammars. They're trying to understand how the rules work, and they use those rules in order to respond to the prompts that are put into the system. So how do we understand this, right? We can think about the text mining process that LLMs use in order to get those examples of observed sentences. So what we want to think about for ChatGPT itself is that it was trained on something called the Books Corpus 2 dataset, which is all of the books that they could find that were out of copyright. A bunch of books, it turns out, that were still under copyright. People are upset about that. And then lots and lots of examples of people talking on Reddit and Twitter. I don't know about you, but if I wanted to learn the English language, I'm not sure that the place where I would go would be Reddit or Twitter. But based on this, there's trillion bytes of data that give examples of how the English language works. And that powers the experience of the model in trying to predict the next token in a series of tokens, right? So using a neural network, there are thousands of weights that are given to the various tokens. And then the likelihood that one of them would be responsive to the input that you have given is calculated. Right? So we can understand this as a regression model. Fundamentally, we're just trying to approximate human language. Right? So you have lots of dots there. You see the line, right? If we can remember some of our high school mathematics, how do we approximate a bunch of data? Right? The approximation isn't necessarily accurate to any one of those points, but it gives us a version that is mathematically consistent with what that data purports to say. So the predictive process of an LLM starts with a text being converted into tokens. You type in a question. Hey, ChatGPT, can you explain to me the rule of law? ChatGPT, of course, is programmed to be very sycophantic. It's very excited to serve you. Right? As the kids might say, ChatGPT is glazing me, right? It's very enthusiastic. It says, yes, of course I can do that. And what it's doing on the back end is it's converting the text into tokens, transforming those into vectors, and then with the mathematics, putting things into context based on the surrounding tokens, which gets passed into a predictive model. The predictive model is going to calculate those weights. How likely is it that a particular token is going to be responsive to the input that you have given? Now, an important thing to know about ChatGPT is that it is a stochastic model. And that means that giving it the same inputs will consistently result in different outputs. And that's part of the way it's designed. If you ask the same question of ChatGPT on different occasions, it's going to give you different answers. And that's part of the way the programming works in order to respond to its creativity. Creativity is also a really interesting factor here because creativity is amounted to a factor called temperature, which is set between 0 and 1, in order to give a little bit of whimsy, a little bit of unpredictability in the outcomes. And so when people talk about hallucination in an LLM model, what they're really talking about is that creativity or that temperature setting. And it is specifically included as part of the way the model works in order to make sure that creative responses are possible, right? Otherwise, you would just get rote responses every time. Maybe ChatGPT wouldn't be so acquiescing or sycophantic in response to people's requests. So when people talk about training out hallucination, it's important to remember that it's actually a feature, not a bug. It's part of the way that LLMs are designed. And the modern models that now say they are reducing error rates with lower hallucinations are using other programmatic advantages to be responsive to that. Things like retrieval augmented generation, which are able to scaffold on other answers to some of the specifics that are done in response. So based on this new model, people are really excited about the capability of ChatGPT and other GPT systems for legal applications, right? You can see examples. I'm going to put a couple here on the screen. Blue Jay Legal, right? They say they have generative AI for better tax answers. Theo AI, they claim they can estimate, right, the odds of success in litigation based on things. And use from various case patterns. Some of us may have heard about Harvey, right? Harvey is a really big model that is used by a lot of firms in order to be responsive to the Gen AI craze. This is from the 2025 Harvey marketing materials, which I downloaded earlier this week. And there's on the full page on the glossy of a lawyer, take away my coffee before my Harvey license, right? There's a desire to represent these new tools by the legal technology industry as fundamental for legal practice, fundamental for the modern era. Why would you ever want to engage in knowledge transfer, knowledge information without access to one of these tools? And so we see a number of growing trends in generative AI. We see a growing number of in-house tools, and that's either people purchasing them off the shelf from different technology firms. The legal technology industry has become enormous in the last couple of years with, billion and trillion dollar valuations. A huge number of companies reported all the time that are going to transform the legal industry and are selling those tools to different firms who are interested in purchasing them. And in addition to that, people building in-house tools, right? Using the generative AI models that are out there and adapting them for in-house purposes, sometimes on secure servers so they can avoid some of the issues around solicitor client privilege, around privacy, around inputting information into those systems that are of concern. Sort of a different angle on the conversation that we could have today. But something to think about too, right? Is like, where is all this data going? Where is it being stored? Data sovereignty issues when data crosses borders, and of course that solicitor client privilege piece at the center of all of it. And then we also see a real ubiquity of these tools. They're being deployed more and more often without people necessarily understanding the full extent of the implications. I have a few more examples here. This one is from Case Text, right? They say, oh, we have an AI legal assistant. Co-counsel, which is from Thomson Reuters, right? They have a generative AI assistant. Lexis plus AI, right? Promises to transform your legal work with short summaries. Libraries are even increasingly making these available to law students with some concerns about academic integrity, plagiarism problems for the legal learning environment, and things like that. And so I don't take a too strong of a position on whether people should use generative AI in general or not. I mean, I think that there are definitely successful use cases, and there are situations where using this type of technology can introduce efficiencies into research and into the practice of law. And there are lots of successful use cases that have been reported in terms of people using it for first drafts, for first cuts, for making an internal chatbot that people can bounce ideas off of, right? A lot of people I've talked to think about it as being really useful for idea generation and being really useful when you have an area of the law that you're really familiar with, right? Like one of my great examples of this, an employment lawyer, um, probably at the bar 20 years, using this to write short summaries of cases for correspondence with clients when she's very well accustomed to doing that kind of work and very familiar with the facts of the cases involved. So she feels confident, right, that this is the kind of work that she can stand behind. I often say that people who have a lot of good experience delegating to juniors, so if you are an experienced lawyer, perhaps an experienced academic who works with research assistants a lot, or you worked with articling students or junior associates a lot, you know how to give people work in a way that will give you back something meaningful, and you know to double check it, right? But we also know what happens when people don't double check their work, which has been widely publicized, right? The first big case comes out in the summer of 2023 when a lawyer uses ChatGPT in a case called Meta and Avianca, right? And there are 3 hallucinated cases included in the brief, where these are complete fabrications that don't exist in reality. And the lawyer sort of unthinkingly cites those cases in what he submits to the court. And everyone gets, upset about that for good reason, because there is that duty of technological competence and also just that expectation of double checking, of understanding the limitations of the technology. At the same time, there's other interesting critiques and analysis of the LLM that can be brought from an access to justice angle, right? If we think about it through the lens of equity and some of the concerns, one of the first big papers and sort of had a corresponding impact on the academic community in this space was this one by Emily Bender and Timnit Gebru and a few other co-authors who talked about the dangers of stochastic parrots, right? What happens when language models are so big, right? When they take so much information from the internet, and that it includes bias, it includes discrimination, it includes undesirable outcomes, and then we kind of allow those undesirable outcomes to propagate under the auspices of the idea that the collective is speaking. Right? You can think about it in the same way that when you have the Google drop-down menu and you see the questions that other people have asked, or these types of things, right? Does it alleviate some sense of personal responsibility to say, people in the world are thinking about these sorts of issues, right? And what does that do from an equality seeking perspective? But for today's talk, I really want to zero in on 3 aspects of the analysis that I have in the paper. And these are the idea of an LLM or a chatbot replacing human expertise, the idea of creating sourceless legal knowledge, and as was mentioned at the beginning, right, the sort of ability of falling into known problematic psychological states. And those are automation bias and automation complacency. And this paper approaches those problems through a lens of automation bias and automation complacency. This is an idea that is well developed in the human computer interaction or human automation interaction literatures. And it talks about what happens when humans are asked to interact with automated systems. And to what degree do humans start to defer to those automated systems because they assume that the automated system has superior expertise, right? They assume that there's something in the black and white of a technological binary that is correct in a way that human capacity could not be correct. That starts to meddle even with people that have a lot of expertise or a lot of experience doing a certain kind of human judgment. And so people become biased in that they think that the technology is better than them at doing the task. And they become complacent in that they just want to allow the technology to drive, right? Just allow it to take over. And I think if we want to think of an example of this that makes a lot of sense to us, most of us can probably remember when we first started getting into these newfangled cars with their advanced driver assistance systems, right? Your lane keeping assist, the bells and whistles, on the side view mirrors to tell you whether there was someone in the blind spot, adaptive cruise control. The one I always think about is the backup camera. Right? When I first got into a car with a backup camera, I said I would never in a million years back up without shoulder checking first. I couldn't imagine something as silly as backing up without shoulder checking. But after a while, that camera, it's pretty reliable, right? Some of the new ones even give you the bird's eye view so you can see the car in space. And so you begin to rely on the system. You begin to allow it to make the decision for you. You begin to assume that the system is better at doing things than you are. And when you start to make those assumptions, what happens to the circumscribed set of uses for which you said that that technology was legitimate? What happens to the fact that you were saying, oh, I'm only going to use ChatGPT for a first draft, right? I'm only going to use those legal technologies for idea generation. And I'm always going to double check it before I send that email to the client, right? Are those things going to remain intact in light of these psychological states? Ones that are well known and well documented in the human automation interaction literature. It's not like this happens once in a while. This happens all the time when humans are asked to interact with automation. So we have the two big examples from the paper are begin with do not pay, right? Do not pay is the world's first robot lawyer, but is neither robot nor lawyer. It was a consumer protection, well, it still is a consumer protection organization that is dedicated to helping people get out of like really complicated consumer contracts. So they will cancel your cable for you when you can't cancel your cable, or they will try to get you a refund from the airline that obviously owes you a refund because they delayed your flight a whole bunch of times for no discernible reason, but you can't get through on the phone. This was sort of their bread and butter and where they began. And in early 2023, they were very excited to announce that they would have the first ever robot lawyer accompany a self-represented litigant to court. What they meant by this was that they were going to have somebody, they were going to be in the state of Massachusetts, and they were going to wear an earbud that would be connected to a Gen AI system that would listen in court and then would tell the person exactly how to respond to the question. And they thought this is transformational for access to justice because it allows people who are self-represented litigants to get access to whatever legal knowledge has been absorbed by they were going to use ChatGPT. So whatever legal knowledge happens to be in ChatGPT. Now there's an immediate outcry about this. A bunch of technology outlets and also legal writers started saying, hey, isn't this practicing law without a license? Right? Doesn't this get into rules of professional responsibility? A number of issues quickly came up. Do Not Pay was threatened with a number of lawsuits. A couple of lawsuits were even filed, including one that I thought was quite funny involving a class action where the class purported to include every single person who was registered as a lawyer in the entire country of the United States. But regardless, they eventually withdrew their idea to have a self-represented person go to court like this for obvious reasons and sort of return the focus of their organization to the consumer rights protections that they had had originally. But I think it's a really interesting example because it shows two things. First of all, it shows the degree to which people are interested in finding access to legal help, right? One of the common quotes that was sort of bandied about when this controversy was making the rounds online was that it's really difficult to find a lawyer who will get out of bed to help you for less than $400. And if the ticket is only for $400, right? Like, how are you gonna access legal help at an affordable level? And so it speaks to this issue of, well, perhaps something is better than nothing, and perhaps this is the way that people in a disadvantaged situation can therefore seek legal help for the first time. But it also talks about the offloading of responsibility to chatbots more generally, right? And we saw something like this happen in a case called Moffat that came through the BC Civil Resolution Tribunal. Some people may have heard about this case. in which a young man was trying to access a ticket from Vancouver to Toronto for his grandmother's funeral, and wanted to use the bereavement prices because it was a last minute ticket for the funeral because she had just passed away, and obviously prices are quite high when you try to book at the last minute. And Air Canada's chatbot advised him that, hey, no worries, you can just book the ticket now and submit the death certificate and the paperwork later. And when he went to do so, Air Canada said, no, no, that's not how that works, and pointed to a different section of the website to say that's against policy and you're out of luck in this situation, and inexplicably um, argued this under a bunch of defenses, but one of the defenses that they tried at the Civil Resolution Tribunal was that they weren't responsible for the claims made by the the chatbot because the chatbot was operating as an independent legal actor. The tribunal member did not find that argument to be convincing, but it is sort of a continuation of an offloading of corporate legal responsibility to these chatbots that has been going on for more than 20 years. And in fact, one of the things that I talk about very much in the paper is a paper written by my mentor, Ian Kerr, and he wrote it in 2004, and it's called Bots, Babes, and the Californication of Commerce, fabulous title, in which he anticipated the degree to which this chatbot craze was coming in a really interesting way. And when he's writing about it, he's talking about it through the lens of consumer contracts. That was a big part of his academic focus, right? Thinking about end user licensing agreements and how are we understanding contracts when they're made with electronic agents. But I also think there's something really interesting there about moral thinking, right? In terms of, well, how do we assign responsibility to these non-human actors, right? How do we think about it in terms of a legal capacity and a legal understanding of what is accurate or what we can feasibly rely upon? And those are some of the problems that arise when you have an AI implementation, right? And what does that mean for self-represented litigants in particular who are trying to access legal services? Are they going to be able to have affordable versions of the software available to them? Is there going to be a stratification of legal help where only people with the very high-end versions of the software, like the very, very high-end fancy firms, are able to meet out legal needs effectively in terms of efficiency and justice, right? Is the information going to be accurate? How are people going to rely upon it? Yeah. And so I think these are really interesting questions and ones that are important to ask in an era when people are disenfranchised from being able to seek legal help and therefore more likely to turn to automated tools in order to give them the legal help that they need. This also compounds the second part of the analysis and sort of the conclusion that the paper drives towards, which is this epistemic problem. If we think about the role of the law in creating order in the universe, or maybe that's just wishful thinking, but law could do that. But right, Robert Cover in the great piece Nomos and Narrative, 1985, talks about this idea of law's surreal epistemology through due process, right? The idea that we sort of can create fact, but we do that in court when we test information. And at least two versions are vigorously fought for and vigorously thought out in court. And there's sort of a collective exercise in which that information is tried before a trier of fact and found to be true or false or non-verifiable, but is always linked to citations, linked to sources, right? Part of the way that the common law grows and propagates is through a continuation of those stories or those narratives that are built by the people who come to court and who build on the law that came before. And so I'm really interested in thinking about ChatGPT or LLMs through this lens of sourceless information, right? Where does the information come from, and where are we able to tie it back to in order to continue building that collective story? And in our modern era, so these are screenshots I took this morning, if we look up the rule of law on Google, before we get anything else, now we get the AI overview, right? And so at the time I was writing this paper, the AI overview had not yet made it to Canada. And then right when I was doing the final edits before publication in October of 2024, it was introduced for the first time. It had been introduced in the US in May of 2024 and then began an international rollout over the subsequent 6-month period in order to have these short AI overviews as the primary piece of information that users receive when they make a Google search. And so if you click show more, you can find out more and you can kind of go into deep dive mode and you can access at least some of the sources that are associated with it. But it sort of supercharges this existing problem that existed online in terms of information being optimized for web search through a process called SEO or search engine optimization. With the idea that you're looking at information in mere little snippets when you do a web search, and that information can often be incorrect or just based on one particular source that the page rank algorithm is drawing from. The first time I noticed this, it was I was trying to go downtown Winnipeg to watch the Winnipeg Jets play, and I wanted to double check what time the game was. And so I Googled, Winnipeg Jets game tonight. And it came up Winnipeg Jets game tonight was canceled. And I thought, what? And it was because it was drawing from a source from May 1st, 2022, which was like over a year earlier, when a game had been canceled due to a really big snowstorm. And so yeah, it had if you like went further, you could find the citation and you could see specifically, the CTV News article that it was drawing from. But it was drawing from something that was irrelevant and over a year old and like specific to a particular thing. And so if you just quickly glance at that, right, what does that do to the systematization of information and the classification of information that we find online? The paper also talks about this section of the Google search results, so called the PAA section, the people also ask section. So what do we look at when we see this type of information, right? How does sort of the impact of technology companies in privileging certain information in the information architecture have on the knowledge that is meted out in different contexts? And of course, thinking about it through the lens of search engines is just one way of thinking about it. But if we think about generative AI or we think about the development of information in other contexts, there's lots of ways to think it through. Another example comes from this case, which is called Snell and the United Specialty Insurance Company from the US, where Judge Newsom was asked to figure out, well, what is the ordinary meaning of landscaping in a contract for insurance? And the reason was there was an issue with the installation of an in-ground trampoline. And so how do we understand the installation of an in-ground trampoline, right? What do we intuitively understand the word landscaping to mean? And Judge Newsom, frustrated by the fact that he couldn't quite sort this out and didn't like the submissions that he had received, went to a number of the leading LLMs in order to give him a response to say, this is what landscaping is. And we can therefore use that definition to decide whether or not it covers the installation of an in-ground trampoline or not. And this worries me, and it worries me for a bunch of reasons. But one of the things I worry about in particular is law's open texture. The way in which, like, if we go back to HLA Hart and we think about the penumbra of law, right? The idea that there is an indeterminacy in the way that law is drafted and the way that law is written that is open to interpretation. And there is a certain amount of ambiguity that is necessary in order to allow that space to make those arguments, right? As part of that building of a collective fiction, as part of the conversation that law develops over time. And so the open texture of language, one of the things that it does is it allows for multiple interpretations of a word, which has been a key aspect of law's process for a long time. And to assume that that is redundant or that is unnecessary, or that there is only one proper interpretation of any given word, and that could be algorithmically determined, based on a machine learning model, I think undercuts some of that functionality that is part of the way law's narrative structure works, right? Because when you have text that is generated in this way, it doesn't make a true bid on meaning, right? Remember, if we go back to what Gen AI promises to do, it distinguishes between long and pedal, right? It distinguishes between grammar and discourse, and between the conveyance of meaning. And so there is no meaning being conveyed in a probabilistic matrix of the most likely token to be responsive to the inquiries that we have. So what does this do to law's collective fiction if we have computer systems that are designed specifically to remove ambiguity, right? To limit the openness of language or the openness of the texture. And so with that, I return to the story about everybody, somebody, anybody, and nobody. And how do we think about those folks in relation to the social function of law, right? Is there a problem with understanding law's method in an era when these things can be specifically determined based on data? And should we be worried about that information that comes from somewhere, but not necessarily attributable to a particular source that we can quote? And so these are some things that I encourage us to think about, because the law is a carefully constructed thing that I don't think we should just throw away. And I think my voice is going to give out any second, so we shall leave it at that, and I welcome your questions.
Wonderful, thank you. Let's gather questions.
I got a question, but I can't figure out how to put my hand up. I'm more used to.
No worries. Great. And feel free to follow Norman's lead and turn on your camera, or otherwise pick the reactions and raise your hand. Great. Norman, go ahead.
Yeah, so just a technical point. I don't think hallucinations are temperature dependent. I think they're a result of helpfulness bias, from their reinforcement training. So, and also they are, the models are still stochastic even if you set t equals to 0, because you can set the temperature equals to 0 on the API interface, and it's still stochastic. So
I
that,
didn't mean to suggest it wasn't.
yeah, all right.
But I do think hallucinations have something to do with temperature.
Interesting.
Yeah.
The other thing is, like in the middle, you're talking about, well, as you get to use it, you get to trust it more. Well, isn't that just experience? I mean, I use it, it works, it works, it works. After a while, it's like, I've double checked it 20 times.
Mm-hmm.
It worked every time. Like, do I really need to double check it? Yeah. So that's, and I mean, I'm working with it a lot. I'll tell you, it's a lot better at stats than I am, has been from the outset. How do I check it? Well, I usually do the stats on 2 or 3 different models, to check it. And then if I don't understand, I ask it, and I've learned a lot. But I just, now a lot of the time I do trust it, and I don't see what's wrong with that, because every time I've asked it a stats question, it's gotten it right.
But if it's so much better at stats than you, how do you know?
Well, as I say, what I do is I go from one to another. if I don't understand. So I have like a physics background, so I understand stats a little bit. So, I understand basic regression and, like a lot of the basic stat stuff. So yeah, I learn. I mean, we'll see, maybe I'll
Yeah.
submit it for a publication and the reviewers will say, this is all crap. But I have also, I have co-authors or like collaborators who've looked at it. So that's how.
Yeah.
And we'll see. Maybe, like I say, maybe I'll send it in and the reviewers will say, where the hell do you get these stats? But I'll bet you money that's not what happens.
Well, I mean, that's part of professional expertise too, to be able to make a decision about when to trust something and when not to.
Mhm.
My concern is more, how quickly do people end up in those states, right? There is sort of a procedural memory that almost is impacted when people rely too much on automation. And um, the one that gets me is like the hallucinated cases. So the example I like to give of this is I did a live demonstration one time of one of these softwares to the Employment Lawyers Association and Employment Lawyers Alliance, the ELA. And I asked them, okay, can you give me the leading four employment law cases? And so it gave me four employment law cases, all of which were real. Two of them were probably, we were talking about specifically the distinction between an independent contractor and employer, so employee. So two of them were maybe more on point than the other two. They were all American cases though, but I didn't specify jurisdiction. That was fine. And then I asked it to, okay, now give me the cases for Canada. And two of the first two cases, absolutely correct. And then the next two cases, it was numbered company versus government department, right? One of them was like attorney general, you
Sure.
know,
Yeah, yeah. I mean, it's
one
totally
was
terrible when you ask it open-ended
transportation,
questions.
like BC.
Yeah, but I mean, it's
And
terrible,
that's
right?
exactly
If
what
you ask,
it would have seen in its training data is numbered company versus government department.
yeah, but I
But
mean, you
they
just
were
learn that.
completely hallucinated,
Yeah, but you just
right?
learn that, right? I mean,
Yeah,
I've learned through experience that it's
yeah,
good at stats. I've learned through experience that it's terrible at open-ended law cases. You
yeah.
absolutely cannot say, give me these cases and expect it to be right. So I
Hmm.
trust it on stats and I don't trust it on open-ended law questions. And it's not because, I mean, maybe me trusting it on stats is whatever bias you're talking about, but it's also consistent with simply learning by experience, which is rational.
Yeah.
When I do stuff, it works. I trust it. When I do stuff that doesn't work, I don't trust it. I mean, that seems okay.
Okay.
Anyway, there we go.
John?
Hi, and thank you so much, Katie. It's so interesting, and I like your slides too. Can you hear me okay?
Yeah, I can hear you great.
You had a slide up there about with showing one of the court directions about disclosure of use of AI. And I'm curious about what you think courts should actually be doing with that information. Because, uh, actually, I mean, people have been using AI for as long as they've been using natural language queries in Westlaw
Hmm.
without realizing it, perhaps.
Yeah.
But now, of course, they're being told, welcome to your co-counsel and Gen AI assistant and so on. So if they disclose all of that for every court filing that they make, what will the court actually do with all that information? It seems to me that you're actually going to end up with information overload.
Yeah. So in my view, I don't think the court is doing anything with the information. I think the court wants to signal to lawyers that they should be thinking about it in terms of pay attention to what tools you're using and try to make sure you're using them responsibly insofar as possible. I can tell you that this direction from Manitoba has not been particularly effective
Mhm.
in terms of stimulating significant disclosures. And part of that is that people don't fully understand when they're supposed to make a disclosure. Is it if they generate their whole brief with LLM? Well, no one's doing that. So, of course, no one's making a disclosure of that. Is it when I used it for idea generation? Is it when I used it to refine a paragraph?
Right.
Maybe not. And so, um, but yeah, I think the directions perhaps should be more limited in terms of what they ask people to disclose, but be directed more towards encouraging lawyers to be mindful of the tools that they're using and responsible for them. I can turn the slides off now, actually.
Thanks.
Chief Justice?
Yes, thank you very much for such an interesting presentation. I look forward to reading your paper. Uh, After ChatGPT came out and before the first direction or policy directive was issued by any court, we had quite a bit of chat among chief justices from across the country. Manitoba, as you point out, was one of the first. Chief Justice Royal. We haven't issued anything in New Brunswick. We're constantly monitoring it. Uh, haven't issued any directive because, quite frankly, it's already provided for in the Code of Professional Conduct for lawyers. So to tell a lawyer to tell us whether or not he or she has used any generative AI, I think it's just useless, to be quite candid. What we're starting to see, though, in the Court of Appeal are much better drafted written submissions by self-represented litigants, much better than 5 or 6 years ago. I can tell you that much. And I have enough confidence in my colleagues at the court that they're not going to take everything at face value. They're not going to issue a judgment quoting at length from a submission from a self-represented litigant without having checked the case law. But it's much more pleasant to read something that is grammatically appealing and well styled and well presented that makes some good valid points than to see some kind of gibberish that sometimes we got from people who had, unfortunately, not the same level of education as many of us have had the opportunity to have. So I embrace the tool. I think it's a wonderful tool. But I do hear what you said though about complacency. I've just acquired this year, as a result of a car accident, a new vehicle, which all of a sudden had all these bells and whistles and everything. And I'm starting to follow them too, and without checking over my shoulder. So I thought that was a good example. But anyway, I think the courts are still going to, I think we have to get educated on it. We have to understand it. But I also think that we can make good use of that tool. That's just a comment, not so much a question.
If I may follow up on the questions that you got for the request from the Court of King's Bench in Manitoba, I was wondering if there is any access to for researchers to get this information. What does the court do with the disclosures that they get? They should be getting some disclosures, and yeah,
I don't know. I could find that out perhaps. They're doing anything interesting with them, but
My understanding is they're not. I mean, I've
if they
spoken to
are,
Glenn. Glenn is a friend of mine. I could be wrong. You can check with them, but my understanding is they just want to be aware so they can be vigilant. If there's a disclosure that AI has been used, they're a little bit more vigilant. But I'm not convinced that they're keeping any kind of statistics. I too can check with them quite easily and give you the information, Aguirre.
right. And to that, because we were talking about liability, I felt that in your paper, you're not sharing obviously the widespread enthusiasm and about the engagement with language generated with popular with the use of popular Gen AI to in for legal purposes, right? And then you're looking at Moffat. So I would say that this is an example that is hopeful. You do see the legal system reacting and responding in a way that you expect, and you're hoping that there common law and the administrative checks and balances are in place to actually react. And I would say the same thing for the case that you mentioned earlier, right? In Massachusetts, where somebody wanted to accompany a self-represented litigant with a not a cure, which was fascinating. I first read about this in your paper. Do you feel that why are you losing your faith in the system's ability to react, to respond to these pressures? If I'm reading you correctly, and does this have something to do with automation bias and long-term effects?
I don't know that I've lost my faith right now. I just think we need to be aware because I think when we have new technologies, particularly I'm very interested in like the science and technology studies literature. And so people like Langdon Winter, he would describe the way we allow a new technology in, right, as sometimes a technological somnambulism, right, like a sleepwalking. In terms of what are the affordances of those technologies, what kind of behaviors do they limit, what kind of behaviors do they augment. And so when I look at the affordances of an LLM and we think through, that in light of what we know about automation bias and automation complacency, these are just things I'm worried about. I'm not saying that the system isn't going to be able to adapt, and indeed the common law has been very adaptable over the last X number of years. But how do we make sure that we don't sleepwalk into a future that is undesirable? And I do think that sometimes there are really enthusiastic calls for over automating the law, right? For saying that there is a right answer to every legal problem, and that if we only had enough data, we could arrive at those right answers. And I think that that is sort of a wrong-headed way of understanding what law's social function is supposed to be.
Yeah, great. Thank you. And John, thanks for everyone for sticking over time. I'm very thankful for everyone's participation.
Thanks, Katie. This is fascinating. I come from, well, a law and translation
Hmm.
like background, and I was wondering whether you have any thoughts around like situations where you might have a foreigner who's using these technologies to interact with the legal system, so they might not be 100% fluent in English or in French, but they're using the technology to produce information to access the legal system. Have you covered this in your research? Has it come up? Do you have any thoughts about it?
That's interesting. I was doing an access to justice seminar for the Manitoba Law Society a couple months ago, and someone asked me about translation in that context. And we were thinking about translation as being one of the great uses of um, of AI, in that it could really just switch back and forth between the languages perhaps more effectively than some other like poor quality not obviously not better than a real human translator who understands both languages well, but are those people always available, especially with lesser known languages or people from really minority language groups who might have difficulty getting access to a translator? But I think, I mean, if you really drill down on it, you might come to some of the same problems, right? Is there good knowledge of minority languages within these types of systems, right? How effective are they at translating between the languages? Do they lose some of the nuance? Do they lose some of the ability to convey meaning? I mean, I will say I did a talk earlier this week. My first language is Hungarian, and there was a gentleman there who also speaks Hungarian. He said he used ChatGPT to write a Hungarian speech for him recently, and he only had to change 3 words, and he was very impressed. Um, so take that for what you will. I don't know. I think it's an interesting thing to think about, both from like an access to justice perspective in terms of making sure that people have access to information, but then also what does it do to the ability to convey meaning? Does it have some of the same limitations?
Yeah, because I have in mind a very particular example that I've
Hmm.
discussed with Argiri and written about on made a post on LinkedIn about it, for example, that there's a dispute between two neighbors and someone asks, well, what is the Greek rule? Because the language I work is Greek. Like, what are the Greek rules about? Like, how do I make a complaint to my about this? And then ChatGPT or the tool that you choose to use produces a whole pile of information that sounds very, very plausible, but and quotes the provisions of the Civil Code of Greece. And then you actually go and check those provisions, and they don't talk about what it's talking about. The legal area is a different legal area, or
Mm.
it contains provisions that aren't actually in the civil code. So the misunderstanding and the confusion that that non-speaker of that language has, and the conception that he develops about the legal system, or that she develops about the legal system before heading to a lawyer to then discuss that, they're in a state of confusion. They think that they have like a cause of action, or they could prepare, and then they have. So they're they're trying to access the justice system, but the tool is creating misinformation for them to a certain extent. And it didn't get better when ChatGPT made its announcements a couple of months ago that, that you should not be using this tool for legal purposes. It might make the disclaimers that you shouldn't be using this for legal purposes, but it continues to produce roughly the same result as it did before. So there's this aspect of like people who are not speakers of these languages in the countries and trying to access the legal system using these tools in their own language before they can go to a lawyer, and then the misunderstanding that arises. I think it's a very, very interesting thing that's quite underexplored.
I agree. I don't know. I think it's a problem, right? It's a problem for access to justice, and it's a problem for understanding, right? How do we switch back and forth between these different lenses? And if you're using, like, if you're going to use it as a translation tool to give you a short summary of another country's laws, then you're going to kind of compound some of those problems when we know that it isn't as good at summarizing really dense, high value information as it could be at other tasks.
Anthony?
Yes, thanks so much. Thank you, Katie, for the great presentation. I agree with a lot of the points you were making, particularly about the role of law. I'm teaching a new course at Dalhousie that focuses on some of these questions, and I've really enjoyed your insights. So thank you. It's not really a point. I guess it's more of a question, a pronouncement, a confession. But in my experience in being engaged in some of these discussions, we often hear about these kind of the dialogue that often we have is this trade-off between the benefits of increased efficiency. We heard a little bit about access to justice, improving the quality of self-represented submissions. And it seems to be indicative a little bit of the state of the legal profession and the administration of justice that we're willing to kind of trade off certain types of like an efficiency balancing with the fundamental process of law and how it's created and talked about, and that we're willing maybe to kind of put those on in a balancing position. And to me, that is a bit alarming that we are that convinced that law can be viewed as a product that can benefit from increased efficiency, and we're willing to kind of see those benefits over preserving something maybe more important than efficiency. That's important, like unique to law's function in terms of stabilizing human relations in society and democracy and so on. So anyway, point being, maybe there's something more sacred than efficiency is my suggestion, and I agree with much of what you said, and thank you.
Yeah, thanks, Anthony. That's great. I also think this, and this is what my book is about, which is about the rule of law and how that works in relation to automation.
Wonderful. And I think with that, we can conclude our great discussion. Thank you, everyone, for being here with us and for staying for a little bit longer. I think that we're all affected by these trends and these developments, and we're definitely concerned and at the same time experiencing the changes. Thank you, and I will be back with announcing the next talk for at the end of the February, and we will be sharing the recording with all of you. Thank you very
Thank
much,
you.
Katie, also for
Thank-
joining us, despite the fact that you're feeling under the weather today.
Thanks, everyone.